Hello, everybody. Roger Royce, 10,000 Startups Podcast. I got a quick one for you, hot off the presses. We just had a decision come down from the Ninth Circuit Court of Appeals upholding yet again AB5. It survived another court challenge. You recall that AB5, Assembly Bill 5, which has been incorporated into the Labor Code, was the provision that really changed a lot of the law. Actually, it codified when our California Supreme Court changed the law, a judicial branch doing something that you might have thought only legislators could do. Well, then the legislature followed up and codified that court decision that makes it very much more difficult for a service provider to be classified as an independent contractor rather than an employee in California. So that's AB5, and that came along back in 2018, you may recall, and it arose out of this very famous case, the Dynamics case. That's where our court rejected the old, what they call Barella right to control test and replaced it with a three-part ABC test. And under that ABC test, it's like I say, it was much more difficult for a service provider to avoid being classified as an employee. In the case, it was simply for wage order purposes, but the legislature eventually expanded that rule to mean basically for all employment purposes. Now, that's a big deal. And everybody knows about that. Everybody heard about that. And it was quite probably in response to rideshare companies. And just to give you a little bit of a walk down memory lane here, because it's kind of important. Your Uber driver under the Borello test could argue that they were not an employee. And I will tell you that most rideshare drivers wanted to take that position. Who wouldn't want to? That means they're not subject to withholding. They don't have to worry about, the extra 30% it typically costs their employer, if they are an employer, to keep them on the payroll. And, they felt like, look, we'd rather have it this way. Of course, they give up a lot. They give up employee benefits that are mandated by statute. They give up payroll, the employer's portion of payroll taxes on Social Security. So, but in any event, our legislature decided that that was a problem, that companies were improperly classifying these people as contractors just to avoid providing these financial benefits. So along comes Dynamics and then AB5. And you may recall what happened next. The rideshare companies put together Proposition 22, put it to the voters, and the voters pretty clearly said, we kind of like things the way they are. We'd rather not have you, the state of California, overregulate our Uber drivers and push them, out of the market so I can't get an Uber anymore, or a Lyft, or a DoorDash, or whatever it is. So that Proposition 22, however, only applied to rideshare. And there were a lot of other bells and whistles to it to provide protections for the people who were drivers. So it left everybody else out there under AB5. Now, here's the interesting thing about that law, AB5. It adopts an ABC test. And here was the test, three parts. The first part, workers free from control and direction of the hirer in connection with the performance of the work. Okay, that makes sense, right? That sounds very much like the old Borello test and the federal test for that matter. B, that the worker performs work that is outside the usual course of the hiring entity's business. Now we're in trouble, right? Right. If you're in the business of providing rides to people and you hire somebody to drive the car, sounds to me like you failed part B. And that's where people got in trouble. And then part C was that the workers customarily engaged in an independently established trade, occupation, or business of the same nature. So it was the B that got, that people tended to fail. And that's in a wide variety of businesses, wedding planners, for example. So anyway, we all had plenty of warning when this came up. And as a lawyer, I've got a pretty good lobby. So we were exempted from AB5 because if I if I got a deposition scheduled downtown and I can't make it, so I call up a friend of mine who's another lawyer and say, go cover this for me. This test would have made them my employee. Well, that's kind of silly, right? So we get an exemption. Well, you know who else gets an exemption? Pretty much anybody with a good lobby. Dog walkers get an exemption. Go figure. I mean, why do dog walkers get off the hook? Handymen get an exemption. And I counted them up one time, and I counted about 60 different exemptions. Someone else told me they counted 100. I guess depends how you categorize them. For example, psychologists and psychiatrists are not treated the same. And you really got to wonder about the wisdom of a law that has that many exemptions and just the way it came about. And that is what this case is about. It's like, look, this is really motivated by animus and not by rationality, right? And that was the words that the plaintiffs use, animus rather than reason. There's no real rational basis for all these exceptions and exemptions, and therefore it fails the Equal Protection Clause of our United States Constitution. Just to double click on that for a minute, because this is an economic regulation. So generally, backing up, the Equal Protection Clause, it really prevents disparate treatment of similarly situated groups. Let me just put that at a high level. However, when it comes to economic regulation, the bar is very low, right? The disparate treatment or the different treatment really only has to have a rational basis. And the court recited that a couple times in the decision. It says we're going to uphold this law unless if there is any reasonably conceivable state of facts that could provide a rational basis for the classification. Well, okay, like, any lawyer worth their salt can string together 4 or 5 different facts to support almost any argument. So that kind of tells you where the case is going to go at that point. And then the case goes on to, I guess, come up and recite some reasons why the legislature might have said, gee, they deserve protection and you don't, kind of thing. But it does seem kind of odd that a worker protection clause would carve out so many workers. And, the other interesting thing about the decision is as you look at it, when you look under counsel, there are a lot of amicus briefs filed in this. An amicus, that's another word for friend of the court, where other interested parties can just go file their own briefs supporting one side or the other. But I was reading through who filed the amicus, and well, first of all, the respondent, of course, is the state of California. So I understand, I get why the Department of Justice is involved. But you know what? The United States Department of Justice Civil Division was involved in this case. I wonder why that is. Several unions are involved in this case. What do they care? Well, think about it. There's good reasons why they care if someone's a contractor or an employee, right? And then several states' attorney general, lots of them, almost all of them. As I look at these, Public Rights Project, Housing Justice Attorney, housing. So it goes on and on. Center for Law and Work, that one kind of makes sense. And then some other law firms representing the truckers organizations, because they've long been litigating over this. So that just tells you what a powerfully politically charged issue this is. And I'm saying this all sort of facetiously because I think we all understand that as California goes the nation, and California was the first, but this is an idea that's gaining traction across the country. Other states have adopted this idea. And in fact, our current Labor Department really loves the California model. And Joe Biden's plan has said that this is the right model. It's the model for the nation and should be part of a federal law. Think about that, a federal law of employee classification. And the difference, though, is the proposal by the current presidential administration would not have any exceptions. So they wouldn't even have this equal protection case. And that would be much more broad and much more I guess, broad sweeping and widespread. So interesting case, upheld once again. Not a big surprise. It's kind of where you would expect the court to go, given the low bar that the law has to survive. And I just think it's here to stay in California and maybe throughout the nation. The state attorney general, not one to ever miss a media opportunity, called it a big win for California workers. You might ask the workers how they feel about that, but at least the state feels like it's a win for them. And also gave a prepared quote that took him a while to come up with. Says the AB5 was enacted to address a systemic problem of businesses improperly classifying their workers as independent contractors to avoid providing financial benefits and legal protections owed to employees. So there you have it. AB5 survives yet another court challenge. Welcome to California. Roger Royce, 10,000 startups.